My name is Nikki Sablett with Healthcare Services Group. I'm the Director of Compliance and Claim Counsel. Thank you for joining us today. I'm here with
Laura Hershinger. I'm a registered nurse and the risk management consultant for HSG. I've worked here for 4 years and I am happy to have this presentation with you all today.
Hi, I'm Stacy Walters. I'm a risk management consultant as well and a registered nurse, and it's very nice to be with you today.
This presentation is near and dear to our hearts. Stacy and I, both as clinicians, have done a lot of work with second victim and the impact of experiencing situations. And so we both worked at an academic medical center prior to this and have participated in research related to this topic, and we actually have developed a program for clinician support. So Stacy and I have a lot of important things, and we have Nikki here to help guide us with the aspects of the lawsuit and claim.
We're here today to talk about the BJC Cares program through Healthcare Services Group. And part of what we're going to do is talk about what is a claim and a medical malpractice lawsuit. So first we're going to start out and have an overview of medical malpractice claims and litigation. We're going to talk about the anatomy of a lawsuit, go back to the basics and go through terms and process. Then we're going to go through the provider's emotional response to an adverse event and the litigation process, which can be quite extreme. Then we'll go through the HSG partnership and BJC Cares program. And hopefully by the end of the presentation, you will understand all of the CARES resources available through BJC and Healthcare Services Group.
So I'd like to talk about after an event. And when we talk about an event, it's really what encompasses an event. And for this presentation, it can be anything. Anything from an adverse outcome, like Nikki was talking about, an unexpected outcome, a complaint that turns into a complaint that actually turns into a lawsuit, just a simple response to a clinical situation, maybe a code blue you participated in, or any other different clinical outcome. So event in this presentation is very broad and very specific. So with that being said, we know that individuals who have been impacted by a situation in which they are caring for their patients, the families of those patients, creates an emotional impact. And any of those events, depending on your connection with the patient and the family, can bring out a real different type of emotional response than what you're typically used to seeing in yourself. And sometimes it takes us off guard because we don't recognize that we have a connection. Maybe it's a connection with, you have children the same age, or maybe it's a connection that you've experienced something similar to them, or you just look at them and see yourself in them. We all connect differently, and it's important to recognize that after you experience something that kind of shakes you, you have a reaction. And it's important to take this serious. It's important to think about how you might respond differently than your colleague, and figuring out how do you get through this impact. And we know that there's growing awareness, as I mentioned earlier. Stacy and I have been part of research related to the emotional impact that clinicians go through when they have been involved in an unexpected event or involved in a malpractice case. And it's very important to go through this and recognize what emotional impact you may have. So as dedicated professionals, we're all focused on taking care of our patients. We are told by facilities where we work at, to be focused on patient-centered care. And when we give of ourselves, we really do give a piece of ourselves to each of our patients and our family members. So when you go through an experience, it is not uncommon to have these type of questions, wondering, what's gonna happen? Well, how are other people thinking about me? Will I ever be the same? What's gonna happen to my license? All these questions can easily run through your head when you're kind of shaken or taken back by a clinical event. It is very normal to second guess yourselves, and these thoughts and feelings can sometimes be expressed out loud. Sometimes you express them internally. Sometimes you've even noticed other colleagues maybe having gone through a similar situation, expressing them or not expressing them. So it really makes you kind of think introvertly and feel, how do I handle this? Is this normal? I don't understand. So what we're here today is to let you know that these are normal reactions to this type of abnormal situation, and we want to explain more about this phenomenon. This phenomenon is called the second victim, and I'd like to read this definition out loud to you. Second victims are healthcare providers who are involved in an unanticipated adverse event, in a medical error or a patient-related injury, and become victimized in the sense that the provider is traumatized by the event. Frequently, these individuals feel personally responsible for the patient outcome. Many feel as though they have failed the patient and second-guessing their clinical skills and knowledge. This is a definition that when we were completing our research at a larger academic medical center, we honed in this definition. The word second victim initially came from a physician, an internist named Dr. Albert Wu, who had initially coined the term in early 2000 when he was writing for Johns Hopkins an editorial article about his experience as an internist in relation to a poor patient outcome, and how he didn't have the support and was trying to seek support. And this is very important to understand, that, and the research has shown us that we know that healthcare workers have been and still continue to be impacted by these events. And we need to talk about it like we are today, and understanding what can be expected. Sometimes, as I mentioned earlier, everybody responds individually, but just knowing that you can have a reaction and it's okay. In the early part of probably your training, I know my training and Stacy's training, we were taught that this is healthcare. Buck up. This is what happens. Patients have cancer, patients die, things happen. You think of all the things we're exposed to as healthcare professionals, and we're just taught to just put on a new jacket, take a breath, walk into a new patient room, when maybe 5 minutes prior to that, we had to deliver bad news to a patient and family member. It's very difficult to change and be present for each patient, and as we think about patient-centered care, we really do give a piece of ourselves. So this program is really to help you recognize that we do have emotions that we need to acknowledge to help move us forward, especially when we're dealing with a litigation case. So I'd like to explain a little bit more about the research. There is a second victim recovery trajectory that we talk about, and as you can see, there are various stages that you go through. And as any event, as we mentioned earlier, as you may experience a situation, you become familiar with it, you are trying to sort out what has just occurred, and you're experiencing your responses, and you're trying to gather your thoughts. And so the first 3 stages kind of happen simultaneously, and you may fluctuate back and forth, especially if that event is being discussed with an attorney, because there's certain things that your hospital or your professional practice may be sorting out, and then if they get an attorney involved in, then will be having more discussions. So then you also are going through the stages of investigation, and Nikki is going to talk more about that in relation to a claim, and then we move through stage 5, which is beginning to figure out how can you find support, how can you find a peace of mind about this situation and still care for your other patients. And then stage 6 is the ultimate goal, right? Is figuring out as professionals, where do we go from here? And I think if you reflect back on your career for yourself and you look at other people you've worked with, you can really see 3 different ways. You have some who've gone into thriving, and these are the individuals who, they make up new programs. They're involved in quality improvement initiatives, and they're out there kind of being the spokesperson for different situations. Then you have the thriving, or the surviving, and these are the individuals who've adapted and they become more cautious. Maybe if they're a surgeon and they really are thinking about the timeout process, you see them, they're meticulous, they thought about things differently. And then you can also have what we try to avoid is the dropping out. And that doesn't always mean dropping out of healthcare altogether. However, I'm sure if you think there's probably individuals that you've worked with who've completely dropped out of healthcare. But there's others who maybe they switched. They switched from being chair of their department and being on the scenes and being in the OR for many days a week to going into a more administrative role, and then taking a step back to getting out of the direct patient care. There is a lot to go on with these processes, and as we go through this presentation, you'll begin to see how these stages impact you as an individual. And Nikki's going to explain more about the anatomy of the lawsuit, and then you can start to see the impact from an emotional perspective. So Nikki?
Thank you, Laura. So one of the ways to help cope with the stress of an adverse event or a lawsuit is to start to understand the different aspects of a lawsuit and go back to the basics that you learned in the very beginning of anatomy. So the anatomy of a lawsuit that we're going to talk about today is first, we talk about a summons. A summons is issued shortly after an event and initiates the litigation process. Then we move into what's called the discovery phase. We go through settlement discussions, and then hopefully you either settle the case or you move forward to trial. So what we're going to do now is take each of those different sections of a lawsuit, break it down, and talk about what it means. So the first part of litigation is when you receive a summons. A summons tells you that a lawsuit has been filed against you. Every defendant named in a case will be sent a copy of a summons, and we have a picture of the summons up on the slide for you so you know exactly what a summons looks like if you ever receive it. A copy of the summons is attached to the petition or complaint that's filed in the medical malpractice action. And when you receive a summons and notice of a medical malpractice action, what that is it's notice to you that you need to take action. Everything in a lawsuit, as you, a healthcare practitioner, participate in a lawsuit, requires some kind of responsive action from you. And so when you receive a summons, the first thing you need to do is A, give notice to BJC Medical Group that you've been sued. You can reach out directly to Risk Management, or you can reach out to Healthcare Services Group. We are your professional liability insurance carrier provider, and we work in coordination with BJC Medical Group's Risk Management to make sure that all lawsuits are taken care of and that defense counsel is timely hired and that your case runs smoothly. So the first thing you need to do is reach out to BJC Medical Group Risk Management or Healthcare Services Group directly. And we will have our phone number and address at the end of the presentation for your use anytime. The next thing that you'll need to do after you talk with BJC Medical Group Risk Management or Healthcare Services Group is meet with the attorney that's hired for you. When you are sued, you will then be provided with assistance through defense counsel to represent you in the lawsuit. You will need to meet with your defense attorney to talk about the case, to review medical records, and prepare your defense. So after you receive a summons, just know that you will have ample time to meet with your lawyer and to prepare your defense, but you do need to reach out timely to your BJC Medical Group Risk Management so that a lawyer can be hired. In terms of taking action, there are also certain actions that you should not take when you're sued. And so we'll go ahead and talk about a list of do nots later on. But next we're going to talk further about the actual summons and complaint. And the summons and complaint or petition, we refer interchangeably to a complaint and a petition. The complaint or petition is required by law to set forth each of the allegations of alleged negligence that the plaintiff is claiming happened in the case. So in that situation, the complaint or petition will go through and set forth allegation by allegation what they believe happened in the case and why they think that they're entitled to some sort of relief as a matter of law. When you receive a copy of the summons and complaint, it may stir several emotions in you, and it's very important that you resist that urge to just toss it in the trash can and ignore it. I turn to Laura and Stacy. Is that a reaction that you see sometimes from healthcare providers when they get notice of bad news?
It's just human nature. It's kind of the fight or flight syndrome that, when something bad or scary is about to happen, it's sometimes easier just to put it away, pretend like it's not happening. The U.S. court system, we know it's adversarial, and it can trigger those additional emotions of, the anger, stress, shame, depression. And yeah, I do think it's a very natural reaction to want to throw the summons away.
So going back to the lawsuit, when you receive a copy of a summons or a complaint that's been filed against you, you do have certain legal requirements that you have to meet. From the date of service, when you receive that copy of the notice and the summons, you have 30 days to file your answer in court. So know that once you receive service of the summons and complaint, that timeline is running and you need to go ahead and take action. Secondly, your professional liability insurance company requires that you give them timely notice of any claim. So it's important that you reach out to BJC Risk Management as well as Healthcare Services Group to let them know that you have been served in a lawsuit. In terms of requirements to take action, there are a lot of things that you as a healthcare provider have to do in a lawsuit. There are also certain things that you should do not do, and I have a list of the litigation do nots, as I like to call them, and we'll run through those here quickly just to talk about some things that you should avoid doing once you receive notice of a lawsuit. The first is resist any impulse that you have to go ahead and dive into the medical record to try to figure out what happened. It's not that you aren't allowed to look at the medical records at some point, but what you don't want to do is go into the medical record where later on, through the pendency of the case, an audit trail will be obtained. It will show to the plaintiff's lawyer and to all other lawyers involved in the case that you did in fact go in to the medical record when you weren't providing care. So the best thing to do when you receive notice of a lawsuit is not to go into the medical record, but simply reach out to BJC Risk Management, let them know that you've been sued, and then they will arrange to obtain a copy of the medical record for you to review with your attorney with as much time as you need. The second impulse that you should resist is not to send out a lot of emails to other folks who may have been involved in the care, to send out to other people in your clinic, or to any personal friends describing what's happened to you, describing the case, or in any way putting down in writing your thoughts about the case. The reason for this is later in the litigation process, you may be required to hand over any correspondence or documentation you've created that depicts your thoughts or care related to the case. So do not create a bunch of email chains describing the care that you gave, any concerns you have about the case, or anything to that effect. Now, there are certain privileges involved in the litigation process that allow healthcare providers to work together to achieve better care. And those privileges, for example, are the peer review privilege. So you can engage in the peer review process without fear of having to disclose records, but simply sending out emails from your own desktop station, your own laptop station, or on your phone, those communications are not going to be protected, so please resist any urge that you have to send out that information. Next, don't talk to anyone else about the care and the litigation while it's going on, except for your lawyer or people affiliated with risk management. I say this cautiously because I don't want anyone out there to think that you can't speak to your spouse or your significant other, parent, children, friends, when you need support and coping. We have part of the BJC Cares program. The entire goal is for you as the healthcare provider to receive the care and the support that you need throughout the stressful litigation process. So when I say don't talk to others other than your lawyers or risk management, I'm saying that from a technical perspective, in that anything that you say that is not privileged can come back later and be used in the litigation process. Typically, healthcare providers are deposed as part of the litigation process, so there will be questions asked of you as the healthcare provider whether you've talked to anyone about the case. At that point in time, you will be required to disclose who you spoke with about the case, so just know that if you've talked with colleagues, if you've talked to other care providers, you will have to say under oath who those people are, and then they can be deposed later in the case.
A natural reaction that many healthcare providers involved in a lawsuit have is also to reach out and first contact the patient or the patient's lawyer. This is a reaction you definitely need to do not do. The patient or the patient's lawyer is not going to give you any answers that you want to have, and any information that you share with the patient or the patient's lawyer can be used against you later in the case. So do not reach out to the patient directly or contact the patient's lawyer. You also want to try to avoid talking with other providers involved in the case. Again, that information can be disclosed later in a lawsuit. Lastly, in terms of creating any type of summary or description of your feelings on the case or any concerns you have about the case shouldn't be created unless it's at the specific direction of your lawyer. If you create a diary or a summary at the direction of your lawyer, that diary or summary may be attorney-client privileged information. Otherwise, you need to be careful about putting anything down in writing that can later be used in the case. Laura and Stacy, we have a lot of legal do-nots. Are there any clinical do-nots that you, from a practitioner perspective, encourage providers to make sure that they pay attention to?
Well, I mean, I know there's a lot of, like you said, a lot of things do not to do, but we do encourage when you're emotionally upset, take a step back. Probably not best to see patients when you're very emotionally upset, and particularly the patient who has the alleged claim against you. So other than that, I know Laura's got some things that we need to talk about related to the emotional, cognitive, behavioral responses, and I think maybe that'll lead us more into some do-nots.
Yeah. So I know for me, just listening to you say the do-nots, Nikki, brings anxiety back to me. I can remember the first deposition that I had, and just the impact of going through this type of situation, it does bring a lot of different reactions. I think as healthcare providers, we're used to teaching our patients and the families about their experiences related to their health, and we're really good at educating them. However, we're not so good at looking at ourselves and educating ourselves and recognizing that those same stress reactions, given the fact that we're going through a stressful situation, we could be experiencing them. So here's a list of some physical responses that you can think of, and I just challenge you to think about, how do you typically deal with a stressful situation? And if you typically find yourself either with fatigue or muscle tension, then this event could trigger that same type of reaction. It's important for you to recognize that, and also recognize that your colleagues may be responding different. And that's just everybody's individual reaction. That's to be expected. Others, I could look at Stacy and I think, oh, she's just managing that just fine. Why doesn't that impact her? But we're all different, and we need to recognize that and accept that in a willing way. And as you continue to recognize what you're experiencing and how it's impacting you physically, I think you need to just really be reflective and be easy on yourself and recognize that it's a common reaction for you, because that's how you typically deal with stress. So there's some emotional impacts that can happen as well. And in the emotional impacts, it's really thinking about, again, what is your typical reaction? And recognizing that this event really shook you to your core. So feeling a panic attack or feeling anger or hostility is normal. And thinking about going back into providing care for your patients can maybe elicit those emotional responses differently. You may notice that you don't have the tolerance to deal with certain patient populations, or things are just settling with you differently. And you think, well, why? You know, I've been through similar situations, but this event, if it really shook you to your core and it's a continuing litigation process like Nikki has been talking to us about, your emotions are constantly changing and evolving. So it's disturbing. As healthcare providers, we trained and educated ourselves to be really good at what we do. And I know you as providers take great pride in that. And when you have somebody questioning your skill and questioning your performance, it is difficult. You think of all the dedication of years of studying, the working 12-hour shifts and being on call, what you do for your patients, that you give a piece. To be a quality physician, you are patient-centered, and to do that, you give a piece of yourself. So when you're questioning, when your care is being questioned, it really is more than just, you know, like a different person working at a different job. This impacts you because this is what you do and what you believe in. So recognize that the emotional response may be even, like I said earlier, it's similar to your stress response, but I think when you think about litigation, the emotional, the anger may feel a little bit different because you're taking it very personal. You care for your patients and you strive to do the best. And unfortunately, right now, if you're dealing with an event, your care is being questioned. So with that, I'd like to move on to how other ways that it may impact you. And this is more in a cognitive way. And we think about this, if you don't have a way to alleviate these emotional and physical stresses, then it really starts to weigh on you in other ways, maybe your performance. And we've seen that in research, and we know now that if healthcare providers don't get the self-care and the support that they need, that we can see similar situations occurring. You know, performance may not be as strong, and that weighs on the provider. So really thinking about self-support and recognizing in yourself that these emotional responses are occurring is very critical. I have spoken with providers in the past, a surgeon in particular, who said, you know, he wished that the research would have been done when he was early in practice, because after years of being in the OR and going through situations on his own, he really felt like his marriage suffered. He suffered physically. He had to have bypass surgery. In the last couple of years, he still wanted to be the provider that he was, but he got out of the OR and he moved into a more administrative role. And he said, I'm satisfied, but he really, now, if he would have known what he knows now, he would have been more supportive of himself and to his colleagues. Because back in the day, it was, this is healthcare, you know, buck up, this is what we have to do, and you have to get through it on your own. And there's not much talking about it. I mean, just think about what we do on a normal day. On a normal day, without any adverse event or harm to any patient, which that's not our goal, you have difficult situations you're faced with. You have patients with cancer who are having a hard time through treatment. You have patients who have young children who you have to tell them have an illness that's chronic and not treatable. You have patients you're putting on hospice. So there's an emotional roller coaster in general in healthcare, and our history is not really being open about those conversations. So when we are faced with a situation like you explained, Nikki, it even puts a harder challenge on the professional, because we weren't taught to be open and speak about our emotions. So I really would like for Nikki to explain more about what this process is, the discovery phase, and after that, Stacy's really going to focus on how we can really hone in on the self-care for ourselves.
Laura, you're absolutely right. In litigation, it is a very long, drawn-out process, and one of the most time-consuming portions of litigation is what we call discovery. And what discovery is it's exactly what the word says. It's discovery about the case. The discovery section of your litigation is where all parties to the case have the opportunity to discover information about the case from other parties. There are two key aspects in discovery. That would be the written aspect of discovery, where each party has the right to send questions to other parties or ask for specific documents. And then you've got the deposition phase of discovery, which typically comes after the written portion, where every party to the case is typically questioned under oath and to give their perspective on the case. The discovery or the deposition portion of litigation can be quite stressful for any healthcare provider going through the process. It requires the healthcare provider to be examined under oath. The deposition testimony is recorded with a court reporter taking down everything that the healthcare provider says. All attorneys in the case are present, and it typically requires extensive preparation for any healthcare provider who is asked to give their deposition. And so what the deposition can do for a healthcare provider involved in the case is make them think about everything that went on in the care involved. It can make them relive the event, and it makes them go through time and time again and think about what happened in the case. This process, because it does require such extensive preparation, can be very stressful. And it's just important for healthcare providers going through the process to remember that they're in unfamiliar territory. This stress is normal. It would be like taking a lawyer out of a deposition and sticking them in the ER, the OR, or a delivery room.
a lawyer in that situation would be incredibly stressed out, just as it's natural for a physician giving a deposition to be stressed out. So these are just normal experiences, and your reactions are okay. And you just need to educate yourself and develop these self-care steps and coping mechanisms to move through it.
Yeah, I mean, it seems like it's a long, drawn-out process. Kind of gives me just anxiety just hearing you talk about it. So it's kind of made me think about a few more things that maybe from an emotional standpoint, there's some more do's and do nots. You know, we already kind of touched on making sure, especially on the day that you're served. If you're upset, you'll be preoccupied. Maybe, you know, not seeing patients just for patient safety on that day. Do not be hard on yourself. This is definitely a time to be reaching out to supportive friends, supportive coworkers for that additional support. What we do want you to do is, you know, take a deep breath and recognize some of your typical responses with stress, and make sure that, you know, you're educating yourself, and that's kind of why we're here today. Identify some self-care techniques that you can use, and seek some support. So with, you know, we most definitely want you to stay focused, and we want you to have some self-care. We do think now is a really good time to find that balance between your personal and professional life. Setting limits for that, but finding time to spend with others that kind of fulfill that peace in you. Making sure that you know your own stress triggers, and making sure that you're using appropriate relaxation techniques. I know for some, you know, that can be yoga, meditation. There's definitely a lot of different stress techniques that you can use. Avoid boredom during this time. Go back to those hobbies that bring a sense of peace to you, whether it's a common hobby that you do every day, or maybe it's one that you've not done in several years, but you know that it gives you relaxation. And then making those healthy choices that we as health caregivers know to do, such as regular exercise. Make sure that, you know, you're eating a balanced diet, moderation in alcohol intake, caffeine in moderation, and getting 8 to 10 hours of sleep. You know, with some of the comments that are on this slide, I think you can probably relate to hearing other healthcare providers who have went through an adverse event or even litigation, because these are very common responses. You know, this event shook me to my core. I'll never be the same. This has been a turning point in my career. These are thoughts that, you know, continue throughout the process, from the event through the process of litigation. I know Vicki's going to further discuss some of the next steps, and I think that's on to settlement and the trial portion.
Stacey, you have a great point that there are different aspects in the litigation, because it does take so long, that can evoke intrusive thoughts and make a healthcare provider feel out of control or more stressed. After they get through the deposition component of the litigation, it really gets to the point of settlement or trial, and those are two major stressors in the case. Settlement means, for lack of a better description, that money is being paid to the plaintiff and the plaintiff's lawyer in return for a complete release of all claims. There are several ways where a settlement can be achieved in a case. A lot of times it involves what's called mediation. That's where a judge, a retired judge, or someone who's very skilled in litigation or personal injury claims will bring the parties together for a meeting, and through the course of a day or 2 days or 3 days, try to resolve a case and bring the parties together to decide what the parties can agree on to resolve the case without having to take it to trial. Parties can also try to resolve the case through what we call the old-fashioned way, and that's just picking up the telephone, calling each other, sending emails, and saying, hey, we want to get this case resolved. Will you agree to XYZ? And seeing if the case can be resolved through that fashion. The settlement process can be stressful for healthcare providers, particularly if there is a consent policy in question. And when I say consent policy, what that means is the professional liability insurance policy that a healthcare provider has may give that provider the right to give consent before any settlement is entered on behalf of the healthcare provider. This is a very important aspect in a professional liability policy, because what it does is allows the healthcare provider to determine if a case is settled or not, and if it is settled, whether there'll be some sort of adverse National Practitioner Data Bank report that's sent off that can impact the healthcare provider's career. So often the decision whether to settle a case can be stressful and conflicting for a healthcare provider, particularly if they feel like they haven't done anything wrong or that their care in question was good. Often I hear healthcare providers telling me that they don't want to settle a case because they don't want it to be seen as an admission of liability or that they did anything wrong. The thing to keep in mind is that often settlement agreements are drafted to where there is no admission of liability, and funds are paid on behalf of the physician in a fashion to where it does not constitute a legal admission of liability. With that said, it is a difficult decision for most healthcare providers when it comes to deciding whether they should settle a case. So please understand that as healthcare providers go through this process, it is a time when they will be undergoing additional stress. If a case isn't settled, then it will move forward to trial. The trial is probably the most stressful aspect of the entire litigation process. It requires the healthcare provider to be present at the trial every day that the trial moves forward. It also requires the healthcare provider to testify at trial and give their testimony to what is called a jury of the healthcare provider's peers, but without fail, in the 20 years that I've been doing this type of work, I've never had a healthcare provider go to a trial and feel like they were actually before a jury of their peers. Without fail, I've had every healthcare provider tell me, I don't feel like this is a jury of my peers, and they're frustrated by the fact that it's not the medicine that controls the case, but rather the jurors who control the case and make a lot of decisions based on their own interactions with the healthcare system or with doctors or with nurses, but not on what the medicine actually is, and it's quite frustrating.
You know, and I'm sure from the jury's perspective, it's more on emotions a lot, you know, so we've got a lot of emotions, and it just sounds like it's very, takes a hard toll on the providers of the case. So I do think it's important, you know, we talked about some research earlier, and it is really obvious that when providers are involved in an unexpected event and don't get the support from their organization, they really feel abandoned. And it also shows that without that support, it is likely that they might even be involved in other events as well. So that's why we're here to talk more about CARES today. CARES is a program through HSG, but also BJC Medical Group, and it's really to help you get through an adverse event or the litigation process. It's really designed to focus on you. You know, we want to help you understand that it's not therapy. It's more about getting you the information for everything from the emotional to the cognitive stages that, you know, you'll work through as you process the event. In our experience, healthcare staff are better able to process what just happened if you understand that everything that you're going through is normal, and other providers have experienced it as well. So what will CARES do? CARES will allow for you to express those emotions, go deeper into your thoughts, talk about those physical reactions that you might be having. We want you to explore things about how you felt about what you went through, because as Laura said, other providers have went through the same thing, and maybe getting education and talking with them really help you heal as well. What part are you having problems with right now? As Nikki said, it's a long, arduous process, and you're going to have different emotions that flow in and out. We also want you to know that BJC Medical Group does have a clinical psychologist that we are working with, and you have direct access to them, or you can reach out to us as well to get that information. We do want to reiterate the fact that CARES is by no means an investigation of the unexpected event. Again, it's about the education and support that we can provide to you. Helping you recognize and understand, maybe even anticipate what you might be feeling tomorrow. Sometimes just giving you the strategies to work through some of those responses can make a world of difference. We also want to make sure that you understand it's purely confidential and protected as part of the claim management service. And we do want you to have our contact information at any time that you feel you need to reach out to the CARES team. The HSG number is located here at the top of this slide. Feel free to contact us, ask on the recorded line. It'll direct you to the risk management hotline. We also want to share Dr. Lotz's direct number here as well. This is for self-referrals, and please feel free to reach out to us at any time. We work together as a team and want to be here to give you the support that you need through this process. We also want to make sure that you have our direct contact information if you would need to at any time. And we hope that this presentation has educated you not only on the legal aspects, but is the self-care and support that we want to give you as well. We really appreciate you for taking the time to be with us today.